What is the statute of frauds in contract drafting? Have you ever wondered why some contracts need to be in writing while others can be spoken? Understanding the statute of frauds can help clarify this important aspect of contract law. The statute of frauds is a legal rule that requires specific types of contracts to be documented in writing and signed by the parties involved to be enforceable in court. This rule aims to prevent misunderstandings and fraudulent claims by ensuring there is clear evidence of the agreement. While many contracts can be oral and still hold legal weight, the statute of frauds applies to certain categories that are significant enough to requiring written documentation. Common types of contracts that must be in writing include contracts for the sale or transfer of real estate, contracts that cannot be fully performed within 1 year, and contracts to sell goods priced at $500 or more. Additionally, contracts involving promises to pay another person's debt, marriage agreements, and agreements where an executor promises to pay debts from personal funds also fall under this statute. For a written contract to meet the statute of frauds, it must include essential details. This includes identifying the parties involved, the subject matter of the contract, and the agreed-upon terms and conditions. Importantly, the writing must be signed by the party against whom enforcement is sought, meaning the party who will be held accountable under the contract. Common legal mistakes in contract drafting related to the statute of frauds include failing to put the contract in writing when required, omitting key terms or parties, and not obtaining necessary signatures. Misunderstanding which contracts need to be in writing can also lead to invalid agreements or disputes. To avoid these pitfalls, it is essential to identify early if the contract falls under any category of the statute of frauds. Prepare a clear, written agreement that covers all essential elements of the deal. Ensure all parties who are to be bound sign the document and keep copies of the signed contracts for future reference. By following these practices, you can reduce the risk of disputes over contract enforceability and protect yourself from claims based on oral agreements that lack proof. Paying careful attention to contract drafting and negotiation helps prevent common legal errors related to the statute of frauds.